This is California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis, Chapter 8, Trial and Post-Trial Motions. Subpart A, Disqualification of Trial Judge. 1. Challenge for cause. Disqualification for actual or perceived bias. The Code of Civil Procedure specifies that grounds for disqualification of judges. CCP 170.1 through 170.9. Disqualification is required, for example, where the judge has personal knowledge of disputed evidentiary facts, served as a lawyer in the case, has a financial interest in the subject of the proceeding, has some relationship with a party or a lawyer, or has a physical inability to properly conduct the proceeding. CCP 170.1a, 170.2, 170.5. Disqualified judge must not further participate in a proceeding except for certain limited power to act as specified in 170.4 pending the assignment of another judge. And that's from CCP 170.3a1, Gelderman, Inc. versus Bruner of 1991, where the judge who disqualified himself after trial and announcement of tentative decision precluded from issuance of statement of decision. A judge must also be disqualified where, quote, a person aware of the facts might reasonably entertain a doubt that the judge would be able to be impartial. CCP 170.1a6c. This potentially broad ground for recusal was interpreted in United Farm Workers of America v. Superior Court of 1985 to incorporate an objective standard. A judge faced with a potential ground for disqualification, quote, ought to consider how his participation in a case looks to the average person on the street, end quote. Of course, the average person on the street does not determine whether a judge must be disqualified. That decision is initially made by the judge himself or herself. 170.3. If a judge who should disqualify himself fails to do so, any party may challenge that judge by a written verified statement of objection setting forth the facts constituting grounds for disqualification. 170.3c1. If the judge still refuses to recuse himself, the question of disqualification must be heard and determined by another judge. See 170.3c5. 2. Under the disqualification of judge section is titled peremptory challenge. Code of Civil Procedure 170.6a1 directs that no judge shall try a civil action when it is established that the judge is prejudged against any party or attorney. Section 170.6a2 then provides that any party or attorney may establish this prejudice by an oral or written motion without notice supported by an affidavit which simply states that the judge before whom the action is pending is prejudiced against any party or attorney or an interest of the party or attorney so that the party or attorney cannot or believes that he or she cannot have a fair and impartial trial or hearing before the judge. If this motion is made according to the time limits of procedures contained in section 170.682, then, quote, without any further act or proof, end quote, some other judge must be assigned to try the proceeding. That's section 0.683. The recommended form and content of this peremptory challenge is set forth in 170.685. A party is permitted to make only one such challenge to a judge in any one action. CCP section 170.683 again, but see the section right before it, A2, authorizing party who filed an appeal and obtained reversal of the trial court's decision to exercise peremptory challenge if the same judge assigned it to new trial regardless of whether that party has previously exercised a peremptory challenge. Why would a party bother to challenge a judge for cause when a peremptory challenge is permitted? Are there circumstances where a challenge for cause is the only procedure available to disqualify a judge? What are these likely circumstances? I don't really understand the questions that they're posing there. Because this happened once in my career. Trial, and it's highly frowned upon. Unless there's like a legitimate conflict. B. Trial by jury. Subpart B. 1. Right to trial by jury. This is demonstrated by a case. C&K Engineering Contractors versus Amber Steel Co. heard by the Supreme Court of California. Justice Richardson gave the opinion in 1978. The issue posed by this case is whether or not defendant was improperly denied the constitutional right to jury trial, according to the California Constitution, Article 1, Section 14. Plaintiff, a general contractor, solicited bids from defendant and other subcontractors for the installation of reinforcing steel in the construction of a wastewater treatment plant in Fresno County. Plaintiff included defendant's bill in its master bid, which was ultimately accepted by the Public Sanitation District, the proposed owner of the plant, after defendant refused to perform in accordance with the bid on the subcontract. Plaintiff brought the present action to recover $102,660 in damages for defendant's alleged breach of contract. The allegations of the plaintiff, first cause of action, may be summarized. Defendant submitted a written bid of $139,511 for the work. Defendants gave a subsequent verbal promise that the work would be performed for the bid price. Plaintiff reasonably relied on the defendant's bid and promised in submitting its master bid. Defendant knew or should have known that plaintiff would submit a master bid based upon defendant's bid. Defendant refused to perform in accordance with the bid. Plaintiff was required to expend $242,171 to perform the reinforcing steel work. As a result, plaintiff was damaged in the amount of $102,660, and injustice can be avoided only by enforcement of defendant's promise to perform. Defendant's answer to the complaint alleged its bid was the result of honest mistake in calculation. Plaintiff knew of this mistake but failed to notify defendant or permit it to revise its bid as is customary in the industry. The plaintiff's conduct in this regard should bar it from recovering damages. Defendant demanded a jury trial. The trial court, deeming the case to be essentially in equity, denied the request but impaneled an advisory jury to consider the sole issue of plaintiff's reasonable reliance on defendant's promise. The jury found the plaintiff reasonably relied to its detriment on defendant's bid. The trial court adopted this finding and entered judgment in plaintiff's favor for $102,620, the approximate amount of its prayer, together with interest and costs. Defendant appeals. Yeah, I'm not sure that's the issue that the jury should have heard. Defendant's primary contention is that it is improperly denied a jury trial of plaintiff's action for damages. In resolving this contention, we first review the nature and derivation of the doctrine of promissory estoppel. Therefore, we discuss certain authorities governing the right to jury trial in this state. The elements of the doctrine of promissory estoppel, as described concisely in Section 90 of the Restatement of Contracts, are as follows. Quote, a promise which the promisor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promisee, and which does induce such action or forbearance, is binding if justice can be avoided only by enforcement of the promise. End quote. The foregoing rule has been judicially adopted in California, and it applies to actions such as the present case to enforce the subcontractor's bid, Drennan v. Star Paving Co. of 1958. It is undisputed that plaintiff's complaint in the matter before us relies exclusively upon the doctrine to enforce defendant's alleged promise to perform its bid. In fact, the language of the complaint summarized above paraphrases that of Section 90 in asserting that injustice can be avoided only by enforcement of defendant's promise to perform. We have recently characterized promissory estoppel as a doctrine which employs equitable principles to satisfy the requirement that consideration must be given in exchange for the promise sought to be enforced. Citations omitted, but they appear to be Radicki v. Gibraltar Savings and Loan of 1974. Italics added. See Seymour v. Ulrichs, 1909, and Klein v. Farmer of 1948. Treatise writers and commentators have confirmed generally equitable nature of promissory estoppel in enforcing a promise which otherwise should be unenforceable. See Pomeroy Equity Jurisprudence Willison contracts, CV reliance upon gratuitous promises or other conduct, promissory estoppel, and traditional contract doctrine. So a bunch of secondary sources, but let's get at this. If it's equity, a judge can hear it. The right to jury trial, which we're going to get to. Alright, before I read into it. So the jury decides legal issues. The judge, equitable ones. As expressed by Professor Henderson, promissory estoppel is a peculiarly equitable doctrine designed to deal with situations which in total impact necessarily call into play discretionary powers within the province of a judge, not necessarily within the skill set of jurors. So, one distinguished commentator has observed that promissory estoppel derives from both the decisions of the courts of common law from the very beginnings of the action of assumption, as well as the decrees of courts of equity making a very flexible use of the doctrine of estoppel. A 1A Corbin Contracts, 1963. The available authorities generally concur, however, that as of 1850, assumpted would not lie to enforce a gratuitous promise where the promisee's detrimental reliance was not requested by the promisor. Citing Ames there and Harvard Law Review. Gratuitous promises, New Writ, Michigan Law Review, Williston, Holdsworth, A History of English Law, 1966. All secondary sources again. The equitable character of promissory estoppel is confirmed by a close scrutiny of the purpose of the doctrine, namely that injustice can be avoided only by enforcement of the promise. Restatement Contract Supra, Section 90, italics added, as expressed by us in a similar subcontractor bid case. Once the prerequisites of the doctrine are met, quote, ... it is only fair that plaintiff should have at least an opportunity to accept defendant's bid after the general contract has been awarded to him. From Drennan v. Star Paving. See also all these secondary sources. Quote, the specific concern of Section 90 with injustice standing alone contemplates broad judicial discretion to make use of equitable principles. We conclude accordingly that the doctrine of promissory estoppel is essentially equitable in nature, developed to provide a remedy, namely, enforcement of a gratuitous promise, which was not generally available in courts of law prior to 1850. We now move to an examination of the authorities on the subject of the right of jury trial to determine whether the equitable nature of plaintiff's action precluded a jury as a matter of right. Part 2 of this discussion is titled Right to Jury Trial. The right to jury trial is guaranteed by our Constitution. I gave Section 16. That's the California Constitution, Article 1. We have long acknowledged that the right so guaranteed, however, is the right as it existed at common law in 1850 when the Constitution was first adopted. And what that right is purely historical question, a fact that is to be ascertained like any other social, political, and legal fact. Okay. People, verse 1, 1941, Chevrolet Coupe, Southern Pack Transportation Co. versus Superior Court. Sorry, that Chevy Coupe one was 1951. The Southern Pack Transportation case is 1976. As a general proposition, quote, the jury trial is a matter of right in a civil action at law, but not in equity. Southern Pack Transportation Code. As he stated in People verse 1, quote, if the action has to deal with an ordinary common law rights cognizable in the courts of law, it is to that extent an action at law. In determining whether the action was one triable by a jury at common law, the court is not bound by the form of the action, but rather the nature of the rights involved in the facts of the particular case, the gist of the action. A jury trial must be granted where the gist of the action is legal, where the action is in reality cognizable at law. On the other hand, that's an end quote. On the other hand, if the action is essentially one in equity and the relief sought depends upon the application of equitable doctrines, the parties are not entitled to a jury trial. See Hartman v. Burford of 1966, enforcement of a promise to make a will. Tibbetts v. Fife, 1958, establishment of constructive trust. Although we have said that the, quote, the legal or equitable nature of a cause of action ordinarily is determined by the mode of relief to be afforded, from Radicki v. Gibraltar, the prayer for relief in a particular case is not conclusive. Thus, the fact that damages is one of the full range of possible remedies does not guarantee the right to a jury, from Southern PAC. In the present case, the complaint purports to seek recovery for damages for breach of contract in the form of action of law in which the right to jury trial ordinarily would exist, from Radicki. As we have seen, however, the complaint seeks relief which was available only in equity, namely the enforcement of the defendant's gratuitous promise to perform its bid through application of the equitable doctrine of promissory estoppel. Although there is no direct authority on point, several cases have held that actions based upon the analogous principle of equitable estoppel may be tried by the court without a jury. Gaff v. Albertson Co. of 1966, estoppel to bar reliance on statute of frauds. Moss v. Bloom, 1964, estoppel to bar statute of limitation defense. And Richard v. Deegan and Brody, Inc. of 1960, estoppel as defense to unlawful detainer action. Defendant responds by relying primarily upon Radicki, which also concerned an action based on promissory estoppel. The Radicki complaint alleged dual theories of traditional breach of contract and promissory estoppel. We stress that the resolution of the instant case did not depend entirely upon the application of equitable principles. The doctrine of promissory estoppel is one of two alternative theories of recovery. Accordingly, we held in Radicki that plaintiffs were entitled to a jury trial and that the trial court erred in treating the jury's findings and verdict as advisory only. The foregoing general principles does not alter our conclusion that the present action is essentially one recognized only in courts of equity, and despite plaintiff's request for damages, is not action at law involving, to use the Radicki language, the incidental adoption of equitable sounding measures. Defendant before us has argued that because plaintiff sought to recover damages rather than to compel defendant to perform his bid, which specific performance would have probably been equitable form of recovery. Rather than to compel defendant to perform its bid, plaintiff requested relief which is available at common law. Yet, we have seen damages at law are unavailable in actions for breach of gratuitous promise. The only manner in which damages have been recognized in such cases of gratuitous promises is by application of the equitable doctrine of promissory estoppel, which renders such promises legally binding. Without the employment of this doctrine, essentially equitable, there is no remedy at all. As illustrated by the express language of Section 90 of the Restatement of Contracts, promissory estoppel is used to avoid injustice by enforcement of the promise. Therefore, the addition in such cases as a prayer for damages does not convert what is essentially an equitable action into a legal one for which a jury trial would be available. This was demonstrated in the recent case Southern PAC, wherein plaintiff sought damages as a good faith improver of land owned by another person. I wonder why they're saying see Code of Civil Procedure Section 871.1 and sequential. The appellate court rejected the contention that plaintiff's request for damages necessarily identified the action as one at law. The court first noted that since the good faith improver statute had no counterpart in English common law, classification of the action as either legal or equitable depends upon characterization of the nature of relief sought, which is a good second approach. When the first approach is not determinative. The Southern PAC Transportation Court properly observed that under the statute, the trial court must effect such and adjustment of the rights, equities, and interests of the parties as was consistent with substantial justice. Again, pointing to CCP 871.5. Thus, the action was essentially one calling for the exercise of equitable principles. The court added the fact that damages is one of the full range of possible remedies does not guarantee real parties the right to a jury. Since there is no possibility of severing the legal from the equitable, the trier of fact must determine whether to quiet title in the improver on the condition he pays the landowner the value of unimproved land, or whether and in what amount to award damages to the improver, or whether to require a completely different form of relief. Such a determination is not susceptible of division into one component to be resolved by the court and another component to be determined by a jury. Only one decision can be made, and it must make a proper adjustment of the rights, equities, and interests of all parties involved. The court concluded that in view of the various equitable considerations involved, it would be an impossible task for a jury to resolve the dispute. Similarly, in the present case, the trier of fact is called upon to determine whether injustice can be avoided only by enforcement of the defendant's promise. The gist of such an action is equitable, both historically and functionally. The task of weighing such equitable considerations is to be performed by a trial court, not a jury. We conclude that the trial court properly treated the action as equitable in nature to be tried by the court with or without an advisory jury as the court elected. The judgment is affirmed. Newman, Justice, dissenting. I dissent. The Chancery Court in England sometimes created rights, sometimes remedies. When California courts decide whether a jury trial should be assured, I believe that they should focus not on rights but on remedies. A plaintiff who seeks damages should be entitled to a jury. One who seeks specific performance or an injunction or quiet title, example, or etc., plus supplementary damages or damages in lieu that would have been allowed in Chancery is not entitled to a jury. The majority opinion here discusses promissory estoppel, equitable principles, equitable doctrine, equitable nature, and even injustice. To pretend that words like those enable us to isolate ordinary common law rights cognizable in courts of law, or that the gist of the action governs, quoting People v. Wan, seems to me to be uninstructive fictionalizing. We are told that courts deal with a purely historical question, a fact which is to be ascertained like any other social, political, or legal fact. Yet how often, I wonder, do or should California judges instead decide whether the wisdom of a Corbin in 1963 outweighs comments by Ames, C.V., Shattuck, and Williston written during the period from 1888 to 1957. In fact, most rights that are now enforced via a jury were created not by courts but by legislatures. We look at the remedy sought, not at the judicial or legislative history of the right, to decide whether the trial is to be legal or equitable. There are troubling borderlines, but the basic rule should be that no jury is required when plaintiff seeks equitable relief rather than legal damages. That approach requires no complex historical research regarding when and whom certain rights were created. It also requires less reliance on the anomalies of England's unique juridical history. Courts thus may focus on a basic policy concern, that is the typically more continuing and more personalized involvement of the trial judge in specific performance and injunctive decrees than in mere judgments for damages. Plaintiff in this case brought damages for an alleged breach of contract. He did not seek equitable relief. Thus, defendant should have been granted the jury trial he requested. Notes and questions regarding right to jury trial, the legal equitable dichotomy. Article 1, Section 16 of the California Constitution preserves the right to a jury trial in those actions in which there is a right to a jury at common law at the time the California Constitution was first adopted. Crouchman v. Superior Court, 1988. Consequently, as C&K Engineering illustrates, the determination of the constitutional guarantee must turn on historical analysis. The basic inquiry is whether the gist of the action is legal, i.e. triable by a jury of common law, or equitable and therefore to be resolved by the court sitting without a jury. Most typical civil actions, such as those for damages based on traditional breach of contract or negligence on one hand, or suits for injunctive relief only on the other, readily fall into one historical category or the other. Occasionally, as C&K Engineering illustrates, an action is not so easily classified. See, for example, Archiero Ranches vs. Mesa, 1993, defendants entitled to a jury trial on cross-complaint seeking injunction to enforce prescriptive easement because the gist of the action was considered illegal and not equitable in 1850. Beasley vs. Wells Fargo Bank, 1991, although the plaintiff was entitled to a jury determination of the amount of damages in breach of contract action, the sub-issue of the validity of the liquidated damages provision must be determined by the judge. Van de Kamp vs. Bank of America, 1988. Gist of beneficiary's action for damages against trustee was based on equitable principle of an accounting and therefore no right to jury trial. Are you satisfied with the gist of the action? Historical approach. What is the source of the approach? Would a better analytical approach be to focus on the remedy sought, not the history of the right, and to require no jury when a party seeks equitable relief rather than legal damages? Why do the California courts not utilize a similar analytical approach? Actions involving both legal and equitable issues. Where legal and equitable claims are joined in the same action, the parties are entitled to jury trial on the legal issues. See Connell vs. Bowes, 1942, Archiero Ranches vs. Mesa, citing cases. Ordinarily, the court will resolve the equitable issues first, and then, if legal issues remain, the jury will resolve them. See Archiero Ranches again. A-C Co. versus Security Pacific National Bank of 1985. Is the equity first rule consistent with the gist of the action approach? How so? Waiver of right to jury trial by jury. The California Constitution permits the waiver of jury trial in a civil action by the consent of the parties expressed as prescribed in statute. California Constitution, Article 1, Section 16. Code of Civil Procedure 631 specifies the ways a jury trial may be waived. These include written consent or oral consent in open court, failure to appear at trial, the failure to announce that a party is required at the time the cause is first set for trial. CCP Section 431D 1 through 4, a party may also waive the right to trial by operation of law by failing to deposit with the clerk certain jury fees in advance of the date set for trial, or additional jury fees as they subsequently become due. If trial by jury is demanded by either party and that party later waives a jury trial, from 631B and C provides that any other party with the opportunity to promptly demand a jury trial.